Welcome, everybody. So we're going to get started here. Welcome to the Importance of Life Planning Documents webinar. Um, I am Michael Lecker. I am the Vice President of Community Organizing here at IMALS. I've been here for 5 years, and I'm just going to give a little bit of an intro to IMALS for those of you who might not know, and then I'll do a little intro to Tim, and then I'll tell you a little bit about the structure of how we're going to be doing this tonight. I do want to first start off with a thank you to Tim, who offered to do this. We so appreciate you sharing your knowledge with us, Tim. Um, and welcome, Meg. I'll start off by saying IMALS is a community-centric nonprofit. We pride ourselves on putting the community first. We provide critical support and resources to those living with ALS, their caregivers and loved ones. We also look to mobilize and empower advocates to raise awareness and resources for ALS, to increase federal funding for ALS, and to revolutionize how it is that we develop treatments and cures by putting the patient first. And we also provide critical support resources to those living with ALS. We are delighted to have you here today, especially because Tim is going to be sharing a lot of important information. The way Tim has set this up is we're going to have 3 parts. And at the end of each part, he's going to pause for questions. If you have a question during that time, feel free to bring it up. If you have a question, though, that you have it now and you want to put in the chat, I'll keep track of it. Don't worry. And then also, Tim is heavily involved at IMALS. So if you have a question for him, send it to me and I'll send it over to him and he'll get it answered right away. Just let you know, you don't have to make sure you get everything covered tonight. So without further ado, I will introduce Tim Abeska, which I didn't ask you for a bio, but I'm just going to wing it, and then you can add anything else you wanted. You asked for a bio for the webpage, but I won't read that. I'll just wing it. So Tim Abeska is the co-lead of the community outreach team. He's also the co-lead of the veterans team here at IMALS. In addition to that, he volunteers his time doing pro bono work, helping people with their wills, living, and other important documents. I won't list them all, but I will let Tim, you take it away and introduce
Thank you
yourself.
very much, Michael. I appreciate all you joining the webinar tonight. I practiced law for nearly 35 years in Indiana before I accelerated my retirement in 2017 when my wife, Marianne, was 2 years into her ALS diagnosis because it was impossible for me to work and take care of her, and she was more important. I still maintain my Indiana law license, but I now live in Maryland where I do pro bono work, as Michael mentioned. And I wanted to talk tonight about the importance of life planning documents for everybody, because everybody who is 18 or older should have these documents because, as we know, especially in the ALS community, nothing is promised to us and life throws us curveballs. And not to have these documents is going to work a hardship on your family because they're going to have to try to pick up the pieces when bad things happen. When I say life planning documents, I am referring to a will, a financial power of attorney, and a healthcare directive, which sometimes is referred to as a living will. And Michael, if you want to bring up the presentation, we can kind of have people watch the PowerPoint. I'm not just going to be reading it, but it gives a guide, kind of a guideline. So if you can advance, please. So we're going to talk about why everybody needs a will and what a will is, why everybody needs a power of attorney and what that is, why everybody should have a healthcare directive. And we're going to talk about some additional steps you can take to organize your affairs for the benefit of your family when you are either disabled to the point where you can't manage your affairs or when you pass away, as we all will. If you can go to the next slide, Michael. And then the next one. So a will is the document which lays out what you want to have happen to your assets when you die. If you die without a will, state law will determine how your assets are distributed. And so some people may think, oh, gee, my spouse will get everything when I die. And that's not necessarily the case because many states have laws that will provide for the children to receive a share um, of assets in addition to the spouse, so that if you think your spouse is going to have everything and will be set, that may not be the case. It gets a little more complicated when blended families are involved because uh, if if the person who dies has biological children and they get a share, and maybe they don't get along with their step parent, who the person passing really wants to take see is taken care of, um, passing away without a will could impact that. Um, a will also gives you a lot of flexibility because if you have specific property, such as a family heirloom or jewelry that has a lot of sentimental value to you, the will can specify the person to whom those assets should go upon your death, rather than just have your family fight over who gets the item or potentially have it just sold with the cash divided between the survivors. A will can also advance whatever charitable giving goals you might have. If you die without a will, none of your assets are going to go to your church or another favorite charity like IMALS. Um, and so a will gives you that flexibility. Depending on your situation, it may make sense to put assets into a trust to protect against someone who might otherwise misuse funds if they get a lump sum of money. And again, depending on your circumstances, a will can be used, possibly in conjunction with a trust, to reduce or minimize whatever tax liabilities you might have under state or federal law. I should note that every situation is different. In our lifetimes, we have all, to some degree, accumulated some money. We have all accumulated some property, but it's different for everybody, which is why a will would be tailored to your specific situation and your specific interests. The other thing a will can do is provide a means for excluding someone who might otherwise inherit assets from receiving anything. And because in some family situations, there's good reasons for doing that. There may be a child who you know would misuse funds. There may be a child who is disabled on Social Security disability income, and you don't want to have receive a large amount of money or any money. When you have assets that pass under a will, the process is called probate. And so the will goes through a probate process, which is a court process where a personal representative, sometimes called an executor, is responsible for gathering all the person's assets, paying all the bills, and then distributing the net assets or the net estate in accordance with the will or in accordance with state law if there is no will. There are ways to avoid the probate process. So, for example, a home which is either jointly titled in the name of spouses or jointly titled in the name of two non-spouses with what's called right of survivorship, that will pass to the survivor automatically and it won't have to go through the probate process. So part of this planning process that everybody should undertake is to figure out how their assets are titled and make whatever changes might be appropriate. In my own situation, our house was titled in my wife's name for various reasons, And upon her diagnosis, we pretty quickly changed that to joint ownership so that when her time came, the house passed to me without going through probate. Bank accounts can be jointly titled, motor vehicles can be jointly titled. In some states, you can actually, instead of jointly titling a motor vehicle, you can name a beneficiary on the title who will receive that vehicle. You can also, instead of putting a person directly on your bank account, you can do what's called a transfer on death or a payable on death designation, where a form is signed with the bank that says, when I die, my account goes to a specific person. Those things can pass outside of probate. Michael, could you go to the next slide, please? Actually, could you back up? I didn't realize. I thought there was one more slide. Sorry. Um, Other things that pass outside of a will or probate would be anything that has a named beneficiary. So a life insurance policy, the named beneficiary will receive the proceeds directly from the insurance company outside of the probate process. But it is very important as part of your planning to make sure that your beneficiary designations are up to date and consistent with what you want. Sometimes people leave ex-spouses named as their beneficiaries. I've seen a situation where someone named left a former girlfriend as the beneficiary, forgot to change it. 20 years later, upon his death, the former girlfriend received a windfall of $1 million. I don't think anybody would want that to happen unintentionally. Some investment accounts or individual retirement accounts also have named beneficiaries, so you can arrange for those funds to go directly to the beneficiary. And again, that passes outside of probate. The important thing is this is an act of love for your family because they won't be left trying to figure out what your wishes are, potentially fighting over assets, potentially disagreeing about what you would have wanted had you only written a will. One thing I'm biased against is going online, finding a will form and filling it out because it's too easy to make mistakes when you do that. And it's also easy to not properly sign the will or witness the will. In most states, a will has to be signed in the presence of two witnesses who also sign in the presence of the person making the will, who is usually called the testator, the person making the will. I've seen situations where someone gets a will off the internet, signs it, and then at a later date has neighbors or somebody sign as witnesses. The dates don't match, which is obvious evidence that the will wasn't validly witnessed, and then the will is invalid. And then you revert either to a prior will, if any existed, or the state laws, which say what happens when a person dies without a will. So I know that's a lot. So I'm going to pause here to take any questions that we may have about wills before I move on.
Go ahead, Meg.
Hey, Tim, thank you for that. I have a question. You have down here like joint assets, like homes, cars, accounts, and stuff like that. One of the things that I've always struggled with right now with one is when we buy cars. We've been trying, and the insurance now, sometimes you can get a loan and then you add that, like if somebody dies, you get the insurance and it'll pay it off. Juan and I've been kind of, I don't know if you can advise on whether or not it's appropriate if I just buy the car in lieu of putting Juan on it, or we buy it jointly and try to get the insurance that goes with it. Because I don't know, some insurances, they don't ask about pre-existing conditions and others do. So if they ask about pre-existing condition, like on like the death benefit kind of life insurance that you get to pay off on a car, but some do. What are your thoughts on that? Should you go and get the life insurance so that when they pass, it's paid off, or what?
If it's important to you that that car loan be paid off, um, then yes, get the insurance. Although I'm not sure that I mean, I know the insurance usually is not a good deal as opposed to just regular life insurance, um, that can be used to pay off various debts if necessary. Um, and whether to title the car jointly or in your sole name is really a matter of preference. But if you did it in your sole name, Meg, maybe you want to have, if Texas allows for beneficiaries on vehicles, maybe have one of the kids as the beneficiary. But if there's a loan, then that beneficiary is going to have to either pay it off or assume the loan.
Yeah, so what we've been doing, and I'm not sure if it's the right thing or not, is I've not been putting Juan on any of like major purchases on our vehicles if I can't. I try to do it all on my level, but I just don't know whether that insurance, and you're right, the insurance is like, I think like $10. I forget what it's like, $30 a month or something like that. But it depends on whether that's something worthwhile for you to have. You're right, depending on whether it's something you need to pay off.
I mean, there's no right, and if it's jointly titled, it's going to go to the survivor ultimately anyway. The only issue is there a strategy involved if insurance is needed to 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 avoid the pre-existing illness, problems that could result.
And you did recommend go see a lawyer versus doing it like, is that what I heard
Yes,
you say?
yes, because a lawyer in your state is going to know exactly what the laws are in your state and potential traps, for the unwary. Like I wouldn't want as a lawyer licensed in Indiana to be doing a will for somebody who lives in North Dakota because I don't know what the law is there. What works in one state may not work for the other. You'll have the assurance that the will is properly prepared, properly witnessed, properly signed, um, and it is worth paying to have it done right than risk a mistake on the back end that can't be rectified.
Can I add one thing about titling cars? Because we do title a lot of cars in my family. There's the titling it jointly with an and there's titling it jointly with an or. And so if it's Meg and Juan, yes, you'll have his certificate that you can present and you get ownership of it right away. But if it's an or, you don't necessarily have to do that if you wanted to sell the car or what have you.
That may be I don't know what every state does. I think in Maryland, we specifically had it jointly with me and Marianne so that the car went to me automatically. But you're right about the and or because that's a distinction that people sometimes don't think about. So thank you, Ellen. Any other questions about wills? Okay, well then, Michael, if you could advance the slide and to the cover page and then the substantive page. The second document that everybody should have is a financial power of attorney, which basically under which you designate an agent, which is often a family member, but in any event, someone you completely trust, an agent who will be able to manage all of your financial affairs if you can't do it yourself. And typically the document would designate a backup agent so that if something happens to the person you designate, there's a second person who can step in. That agent can do just about anything under a power of attorney, sign contracts on your behalf, manage your bank accounts, pay your taxes, hire lawyers, hire accountants, pay insurance policies, take out insurance if you need it, um, deal with retirement benefits, everything you would or could do on behalf of yourself, you can vest an agent with authority to do under a power of attorney. These are sometimes called durable powers of attorney, but all that means is that if you become disabled, that the power of attorney remains in effect so that your agent can act on your behalf, which is the whole point. And it is imperative that this document be signed while you are still competent to sign a legal document like this and understand exactly what you're signing, because this also has to be witnessed. And in some states, like where I live in Maryland, it also has to be notarized. So the time to sign a power of attorney is not when someone begins showing or has shown signs of FTD, early dementia, is lying in a hospital bed after a car accident where there's cognitive impairment and they don't understand what the document is or what they're signing. And I've been in too many situations where I'm in a hospital room or a nursing home room and I'm trying to explain to somebody what their relatives want them to sign and they don't have a clue. And I can't in good faith witness that. And I've been in situations where people from the nursing home or the hospital will say this person has X, Y, or Z ailment, should not sign this, cannot understand what they're signing. So that's why you should do it sooner rather than later. And hopefully the power of attorney will just sit in whatever file or lockbox that you have where your important papers are and never need to be used. But if the time comes where it has to be used and a power of attorney doesn't exist, it can create real problems for your family. Because if you, for example, have a bank account in your own name, no one else can withdraw money from that account if you don't lay the groundwork for an agent under a power of attorney or a joint account holder. um, no one is going to be able to talk with lenders on your behalf because they're not the borrower. But if you have a power of attorney, you act as the agent and you can do whatever the person granting that power of attorney is able to do for themselves. Um, and it may be that keeping insurance policies in effect is very important, and the agent can do that or make sure there's money in your bank account if your bills are on auto pay, handle all that for you. So that's the second piece of this, is to have a power of attorney. The will comes into play when a person dies. The power of attorney comes into play during the person's lifetime when they are unable to manage their own affairs. Um, so I'll pause here to see if people have questions about the power of attorney aspect of this. Meg?
Sorry.
No, that's funny. I see your hand go up. That's great.
When Juan was in the hospital, that was something that we had to deal with, but especially the power of attorney because he was unconscious for some of it, right? So is there a time limit on the power of attorney? Like, do you have to have it renewed every so many years or something, or is that state driven?
Um, I'm not aware. I think it would be unusual for a state to say that a power of attorney is only valid for a specific period of time. Most states have a statutory form of a power of attorney. So really all you're doing is plugging in the names of your agents and making sure that it's properly witnessed. A power of attorney could specify an end date, but that's pretty risky because if it terminates and then doesn't exist and the person becomes physically or mentally disabled, unable to handle their affairs, um, then there's no power of attorney. So it's far better to leave it as something that remains in effect unless revoked or replaced by a new power of attorney. And on the hospital piece, we're going to get to that because the healthcare directive is important when a person's in the hospital unconscious. The financial power of attorney covers financial things like paying hospital bills, for example. But the next thing I'm going to talk about is the healthcare directive. Does anybody else, though, have any questions about powers of attorney?
When does the power of attorney kick in? Because I still be cognizant as a stand as my power of attorney and have to take over things.
So there's two ways you can do it. One, the power of attorney can just simply say it takes effect immediately. Um, or the power of attorney could say it takes effect when a doctor certifies that I'm not capable of handling my affairs. I will tell you that my own attorney told me make it effective immediately and just keep it in a safe place. And your husband's certainly, not going to run out and, do things he isn't supposed to. But my attorney told me that if you require a doctor's certification, if you've got somebody slipping into dementia that has good days and bad days, and the doctor catches the person on a good day, the doctor will say, I can't certify that they're not able to handle their affairs. I see, Ellen, you're nodding because I expect that perhaps your experience with your husband Larry was good days and bad days.
Well,
Uh,
I see this with, because I'm part of a support group, I see this with people all the time. I see this with people who don't have the proper HIPAA forms and can't get to the doctor to get the doctor to sign a form for them because, the doctor feels that this person is still capable of managing their own affairs. The person says they're fine, they have anosognosia, they don't know that they're sick, and the resistance to the idea, then the caregiver cannot actually get that form signed either. So it's really important.
but Stacy, I think, to your question, theoretically, if the power of attorney is in effect immediately, if the agent has a fiduciary duty not to mismanage your assets under the power of attorney, mine, for example, is in a lockbox, and if need be, one of my nieces would use the power of attorney to act on my behalf. Um, that's why you want to keep it in a safe place.
So if it takes effect immediately, can we both be managing? Or
Yes,
the,
you can manage your own, or you can send your husband down to the bank with the power of attorney in hand to withdraw money from your bank account or something. Yeah, that's
thank
absolutely
you.
right.
Thanks.
Any other questions relating to powers of attorney? Okay. Michael, if you wouldn't mind advancing. So the next thing is, in these documents, the next document that I'm going to talk about, the, what it's called could vary from state to state. It could be called a healthcare power of attorney. It could be called a medical directive. Sometimes it's called a living will. But the point is, this is a document that you sign to identify an, a person who will act as your agent to make medical decisions on your behalf if you are unable to make them. And in this document, you can lay out what you want to have happen. Do you want there to be a DNR? Do you want, if you're in an end stage condition or in a vegetative state, do you want everything possible done to keep you alive for as long as possible? Do you want nothing done? Do you want no extraordinary means undertaken, but at least give you hydration by tube and nourishment by tube if need be? Those are the kinds of decisions that you get to make in this document, and then the agent you appoint will act consistent with your wishes. And in the Maryland form, you can either specifically say, I'm giving my agent some flexibility because I can't foresee every possible circumstances, or you can say, I'm not giving my agent flexibility. You do exactly what this document says. Um, if I can't make my own medical decision. And then this document can also cover things such as, do you want to be an organ donor? Do you want to donate your body for medical research, as some people do? What do you want your funeral to look like? Do you just want to say, my agent should handle my funeral arrangements? Um, or do you want to spell out exactly what you want? I've seen it both ways. Some people that I have worked with provide great detail about what they want their funeral to look like, right down to where they want their ashes distributed. Others just leave it up to the agent to decide and say, keep it, they may say, keep it simple, or may give me a church funeral. But um, again, these are your personal decisions. And if you don't have a document like this in place, no one's going to know what your preferences are for disposition of your body in a funeral. But more importantly, if no one necessarily is going to be able to act on your behalf to make medical decisions if you don't have a healthcare directive in place. Look at me. I'm a widower. I don't have children. No one's going to be able to make my decisions for no hospital is going to listen to anybody who isn't designated as my agent under my document. And nobody thinks about this. People people turn 18, people are in college, they think they're invincible. What happens if that student, God forbid, gets in a car accident and is seriously injured? Someone needs to be online to be able to make the decisions, because when you're an adult, the hospital may or may not listen to the parents. So are there questions about this document? Danielle says we were able to do this form at our ALS clinic. That's great. That is great.
Tim, this is Yvonne. I have a question. I was actually I'm in Virginia, and I know every state has their different forms that you have to fill out. However, right here, right now, a friend of mine has kidney disease. She doesn't need a kidney right now, but she might need a kidney. And I'm thinking maybe I should get tested to see if I'm compatible with her, because if something happens to me, my kidney's viable for her. I want to give my kidney to her. So I can put that in there, correct?
You certainly could put that in there. Now, I don't know how the transplant process works. I don't know that you can necessarily designate the person to whom you want the organ to go to, but in my mind, it would be worth a try, especially if you know in advance that your organ would be a match for a specific person.
Thank you.
Tim, can I ask, are you planning on talking about how a post or a most might work in concert with this form?
I am. That's actually next.
In the chat, Meg says same, but it didn't go that deep. More what Juan's desires and the life-saving. Didn't know this should be on this form, just thought the will.
So, Meg, the will becomes operative when a person dies. So you want one's desires laid out in the medical directive or the living will. And that can, you want to do not resuscitate order, or you don't. You want heroics undertaken to keep me alive. It's the medical directive or the healthcare power of attorney where you specify all that.
I was talking more if you want to be cremated, what your funeral required. I thought that was part of the will, the DNR piece or whatever your life-saving events are from this portion. But like, I thought that if you wanted to be cremated or if you want your body donated, that was part of the will.
The will would work for that, because there's usually boilerplate in a will that says, that the executor or personal representative should pay my funeral expenses. And some people do just put right in there, this is what I want. The kind of monuments, what cemetery I want the plot in. Yes, you can do those things in the will. It's the medical wishes that should not be done in the will.
So like if he wants his body donated, he should say specifically in the will what agency that he wants his body donated to for ALS, not just to science type of thing.
I would actually put that in the medical directive or the healthcare directive. Say that upon my death, here's where my body goes. And I know that so I know there's an organization that actually just came to community outreach within the last month that does these donations for ALS purposes. Texas, like Maryland, probably has a specific agency or hospital where you designate the body goes to if it's just for general scientific research.
Yvonne, did you have a follow-up question?
I have a question. Um, it's sort of a broadly worded one, but there's a number of permutations of where you could go with respect to life-saving actions. And do you have a recommended set of wording or choices of wordings? Like, for example, if one would say, well, in general, DNR, but well, I'm going to bounce this example. I'm sorry.
That's okay.
If there was a situation where you would say, if I need a breathing device to keep me alive, and I'm unable to breathe without that, how is that handled? To say it's okay to take me off the breathing device? Where do we cross the line? And on all these gray areas, like, does that become, again, forgive me for the crudeness of it, does that become assisted suicide or something like that? How do we get answers to these type of questions?
Okay, so it's a very good question. Certainly difficult subject matter, which I understand, but the medical directive or healthcare power of attorney is the place to specify that. If you specify that you do not want to be trached, that is not assisted suicide. If you specify that, and because I've seen people do it, if you specify that you do not want to be intubated more than X number of days, and that if you can't breathe on your own, you are not to be kept breathing by artificial means, that's not assisted suicide. But it's imperative that you lay out those wishes in the document so that your loved ones know what your wishes are. Does that help you, Alan?
Yes, I think, and then it just really, would you advise that we deal with the attorney who's doing the will to get that wording right?
Yes.
Or is there a place where IMALS has suggested wording? Or
okay, I don't know if IMALS has suggested wording. Typically, the same attorney who does your will and power of attorney would also do the healthcare directive. It's really they're part of a package of documents, basically.
okay.
Yeah, just to clarify, we don't have standard boilerplate language available, and if somebody asked us, we'd probably send them to Tim or one of our other nonprofits we work with that has access to lawyers. So, Alan, we can chat later if you'd like and talk about that. There was a question in the chat I just want to read out loud.
Thank you.
Oh, you're welcome, Alan. Tom said, "Is it best to use an elder care attorney?" Ellen responded, "It was worth every penny for us, Tom. Our general attorney didn't have as much knowledge about financial planning necessary for our medical situation." Tom gave a thumbs up. And then Meg said, "Yvonne, what a wonderful offer for your friend, by the way."
And I'd like to just amplify on that Q&A a minute. When I think of an elder law attorney, I think of someone who is working with clients to do Medicaid planning and figure out what you can do with your assets to preserve them for the family if in the event that Medicaid funding is going to be needed for your care. when I think of an attorney as opposed to a generalist, I think of them as an estate planning attorney who knows the ins and outs of the laws relating to wills and probate and those things. It may not be a meaningful distinction, but that's just my view of the world on that. But you do want somebody who's knowledgeable on the subject matter for sure. And I agree with Ellen's comment. It's well worth the money.
And I think you have to be very concrete in your mind and heart about what you want very specifically, because it's like, what do you want your family to go through, or what you want very specifically, and put that in there, because you never know what your family might do to keep you alive.
Oh, well, that's right. I mean, look, when my father died, he didn't have a medical directive, and four of the kids were ready to let him go, and there was a holdout, frankly. And my father passed on his own before we had to really like hash that out. But um, it that's why everybody should have one of these. These are great questions. Does anybody have any other questions?
In the chat, Ellen put helpful link if you're seeking elder law attorney, and then www.naela.org. And then Aditi said there are also grants to help people cover the cost of legal fees for this.
And again, everybody's financial situation is different. There are pro bono organizations, such as the one I do work for, where if you qualify for services based on your financial situation, you can get matched up with a lawyer who will do this at no charge or a reduced charge. So that's a great suggestion, Aditi.
So, Tim, I'm currently in Virginia, and it's a possibility that I might move to another state. If I do all of my everything here, when I go to my other state, I still have to look at what their requirements are and go through all that again, or does that supersede anything?
No, if a will is valid in the state where you live at the time it's signed and you move, it remains valid.
Thank you.
The rule of thumb is every 5 years or so, everybody should evaluate how their situation has changed and whether the will should be updated. But the mere fact that you move to a different state doesn't change anything. I see Christine in the chat says the 5 wishes form is helpful. I am familiar with that form. The other one I want to talk about, Ellen alluded to, depending on your state, it's called a MOLST or a POLST, but it's like the MOLST in Maryland, it's Maryland Orders for Life-Sustaining Treatment. Here, that is a form that your doctor fills out in consultation with you, and that's the document that lays out whether you want a do not resuscitate order, what specific instructions you may have. And here, paramedics are trained to look at someone's refrigerator to see if that document is taped or stuck to the refrigerator with a magnet like mine is, because if they do not find a do not resuscitate order that's in plain sight, they are required to resuscitate you. And again, not everybody wants that. But that form, at least here in Maryland, is filled out by your doctor. And Ellen, do you know if that's the case in Florida?
It is the case in Florida, and also it's important to note that it's something that you can revisit every time you visit with your doctor. You may change your mind about your directives, and so you can fill out a new form if your situation changes. It's something that you should talk over either with your palliative care doctor or your primary care physician to have in place at all times.
Not funny, but I saw a TV show where a guy actually had it tattooed on his DNR on his chest. And they opened it up, and they were doing CPR, and they opened up his chest. They're like, "Oh, everybody stop!" It was an interesting. I don't know if that would be even legal to do that. But anyway, TV.
Yeah, I wouldn't rely on that. I wouldn't rely on the tat. I would just, pay take the money you'd spend on the tattoo and have the document prepared.
The other thing I wanted to ask, I have heard that even if you have a document like this in place and family members are in the hospital, it's possible that the hospital, and there's one person who's resisting, it's possible that the hospital would go with that person's wishes as opposed to what is on the document. Do you have any information about that?
I don't, but I would say the hospital, while they shouldn't do that, the hospital is always going to have one eye on potential liability, and probably consult with their own lawyer about what they should do in a particular situation. But the whole point of these documents are to put the control with the person who is ill or in the hospital. I mean, sometimes, look, a parent, for example, may have specific wishes, and sometimes there might be a child that just can't let go. These documents are intended to circumvent that, to be able to have the person's wishes trump the situation. But for sure, if there is no document and there's disagreements, the hospital is going to take the path of least resistance.
In the chat, Danielle said, if your work has an EAP, the services are sometimes offered. Legal fees and such.
Thank you, Yvonne. Michael, I think there might be one more slide left, just so I can. Okay, that's the. Yeah, we've talked. Okay, so we've talked about the MOLST or state equivalent form. I've mentioned beneficiary designations, that you want to make sure everything is updated. And Michael, is that the last slide, or is there one more? Let's see, the other thing that your loved ones need to know: where do you keep your important papers? Who is your lawyer? Who is your accountant? Who's the financial person that handles your IRA, so that they know who to call when the time comes? What are your passwords for all the accounts, the online accounts you have, like your bank account for sure, credit card accounts, and so forth? Um, what are your credentials for your social media accounts? Do you want those accounts to stay on after your death, or do you want your personal representative to terminate them? How do you pay your bills? Make sure somebody knows that, so that they know what kind of money needs to be in an account. Or if your bank account ultimately becomes the account of an estate, that the automatic payment mechanism gets transferred over. So those are just some practical suggestions to help your family members. And then if you have a centralized place for your documents where you've got important papers like your passport, your social security card, your motor vehicle title, your Veterans Administration's records, then somebody's not having to root around 5 different places in your house. They have them all together. I would tell you that when my wife was diagnosed, one of the first things she did, she put all her jewelry in Ziploc bags, and she created labels and told me exactly who was to get what was in that bag, which was, as you might imagine, a big help to me, so that I didn't have to try to figure it out. So we're basically at the end of the presentation, but I would love to take any other questions that you might have. But to that one box on the upper left, sooner rather than later. As we know in this ALS community, nothing is promised to us. You make your life plans, things happen to derail those plans in an instant. So the time to do it is before a difficulty arises. Does anybody have any other?
This was really great. You made it very digestible. It's an overwhelming, subject matter. have a lot of work to do. They can really get me started.
Thank you,
I could,
Stacy.
if I could just make a comment, I mean, we talk to people who are just getting diagnosed, and it's a really overwhelming time. We kind of talk about the hair on fire year where you're trying to get everything in place. And once a family has put these documents into place, that really does help to calm down that hair on fire feeling. It makes you feel like you have greater control over the situation, and you have a better understanding of your path forward. So it's one of the first things that we recommend to someone when we start talking to them.
Thank you, Ellen. And to the question in the chat, yes, if you travel out of state, as long as your power of attorney or healthcare directive are valid in the state where they're signed, the mere fact that you're traveling someplace within the United States won't change that. I can't speak to what might happen if you're in a foreign country.
So do you have to travel with it?
That would be my recommendation, that you have the document with you in case something happens.
I think the thing that
Yeah,
scares me, I'm sorry, I think the thing that scares me the most, quite frankly, is um, I've asked Juan to kind of go through some of the things that he has that he wants to distribute out to either his brothers or the kids and make sure that he's got this, or specifically things that he wants for his funeral, specifically things that he wants to do. I'm not worried about passwords and stuff like that because I'm working on his phone and I have things like you just said, Jesse, you put things out on Toby and stuff like that. But I worry more about not meeting his wishes, like, and that's a hard thing to ask because right now it's like he's like, well, I'll do it. But when we were in the hospital just recently, it's like they coded him, and I was like, well, I don't know what I would be doing now if I had to deal with him because, if I had lost him, I didn't have anything really planned. I knew some of his wishes, but not all of them. So I've been trying to get him. That's partially why I have been working on this. I'm just trying to make sure that he has all of the things that he is needing and desiring so that it's not so much of an issue for me.
And in your situation, and as a practical matter, it's not like you file a will to be able to distribute, something to his brother that he, one wants it to get there. As long as it's in writing so that you have the guidance about what he wants, then you'll give the property to the brother or the child or whomever.
In the chat, Jesse said, just to share, I have auto-fill password in my Toby in terms of paying bills. I did screen recording to show my husband how. I uploaded the video as private on my YouTube account. That's brilliant.
That's brilliant.
And when I was in the hospital in December with septic shock, and at one point I thought I was going to die. And one of the things that kept me alive was the fact that I hadn't completed all of this stuff yet. It's like, I absolutely don't want to leave that for my husband.
And I'm sure that he appreciates that.
Yeah, thank you for sharing.
If I can add one more thing if we have time. While you're making these plans for your family, those of you who are patients are looking at it from one angle. Those of us that are caretakers are looking at it from another angle. We have to also think about what happens if we, the caretaker, become ill or incapacitated and can no longer care for our person. And so those plans that you're making have to include, who's going to take over your finances, who's going to take care of your children for you, etc. So it can be really, really complicated and complex. That's just another angle to think about.
Well, that's a great point, Ellen, and it, underscores what I said about everybody needs these documents, and that includes the caregiver. We're not just talking about the person who's been diagnosed with an illness. We're talking about the caregiver, because if something happens to the caregiver, there has to be a means for someone else to step in. or, an agreed upon guardian or somebody to take over the care of the
Or a
person.
trust to pay for that care.
Correct.
All right, that's it. I'm texting my kids and saying, which one of you wants to deal with it when we're done? I know which one I don't want to deal with it.
And
I gotta
Well,
go. I got a phone call, so I'm gonna let you guys on mute.
But what Meg was just talking about in a joking matter is you do though, if you have a child or a person really isn't going to be the person to manage your estate, don't make that person the executor or the personal representative under the will. Name a responsible person.
And I will just share, after our journey, I went to each of my adult children and paid for them to have these forms put into place as well. So
Good
that
for you. Good for you. If that's what it took, that's great. Well, I appreciate everybody taking the time to listen to this, and hopefully you got some benefit out of this webinar.
Thank you, Tim.
Thanks, Tim.
Thank you all. And thank you so much, Tim. And just to conclude this, if you do have any questions, my email is pretty easy to figure out. It's michael@imals.org. Send some questions. We can get you connected to whatever resources you need. We have an incredible community support team who will do that too. So yeah, just keep the conversations going and let us know if you need anything. We'll be posting this recording online too, so that people will have access to it and you can, refresh it. And just remember, if you have more questions later on, we're here. All right, everybody, you have a good night. And thank you again, Tim, so much. We so appreciate you sharing your knowledge with us.
You're welcome. Happy to do it. Thank you for asking me.
Bye, everybody. And go bananas.